Have you ever stopped to think about what would happen to your loved ones and your assets if something unexpected happened to you today? It's a question that often makes us uncomfortable, but it's one of the most crucial considerations we can make for our future and the future of those we care about most. We all have hopes and dreams for our families, for our legacies, and for the things we've worked so hard to build. But without a clear plan, those wishes might never see the light of day. Instead, they could get tangled in a lengthy, public, and potentially costly legal process called probate. Probate is essentially the legal procedure that validates a will and oversees the distribution of a deceased person's assets. While it serves a necessary function, it can be a slow, expensive, and emotionally draining experience for your grieving family. Court fees, attorney fees, and administrative costs can quickly eat into the inheritance you intended for your beneficiaries. More importantly, the entire process is public, meaning your financial details and the specifics of your estate become a matter of public record. For many, the idea of their private affairs being laid bare for anyone to see is deeply unsettling. And perhaps most frustrating of all, the probate process can take months, or even years, delaying your loved ones from receiving the support and inheritance you intended for them. This is where a properly executed last will and testament comes in. A will is a foundational document in estate planning, a legally binding instruction manual for what happens to your property, your money, and even the guardianship of your minor children after you're gone. It gives you control, peace of mind, and helps ensure your wishes are honored without unnecessary complications. It allows you to name an executor, the person or institution responsible for carrying out your instructions. It lets you specify who receives what, down to specific items or percentages. And crucially, if you have young children, it allows you to designate a guardian, ensuring their care is in the hands of someone you trust implicitly, rather than leaving it up to a court. Now, traditionally, creating a will meant scheduling appointments with an attorney, navigating complex legal jargon, and often incurring significant legal fees. For many, this presented a barrier, making estate planning feel inaccessible or too complicated to even start. But in our increasingly digital world, new solutions have emerged that aim to simplify this vital process. One of the most prominent players in this space is LegalZoom. LegalZoom has revolutionized how many people access legal services, and creating a will online is one of their flagship offerings. But what exactly is LegalZoom, and is it a legitimate and reliable way to create such an important document? LegalZoom is an online legal technology company that provides a range of self-help legal services, including the creation of wills, trusts, business formation documents, and intellectual property filings. Since its inception in 2001, LegalZoom has served millions of individuals and businesses, aiming to make legal processes more accessible and affordable. Their approach centers on user-friendly online questionnaires that guide you through the process of generating legal documents tailored to your specific needs and state laws. So, how does creating a will online with LegalZoom actually work? It's designed to be a straightforward, step-by-step process. First, you'll visit the LegalZoom website and navigate to their last will and testament section. They offer different packages, typically a basic will plan and a premium plan that includes attorney assistance. The basic plan for an individual can be around $99, while a premium plan with attorney review might be closer to $249. For couples, these prices are slightly higher, approximately $199 for basic and $349 for premium. It's important to note that these are one-time fees, although LegalZoom does offer annual subscriptions for continued attorney advice and unlimited revisions after the initial period. For example, attorney assistance after the first year renews at $199 annually. Once you've selected your desired package, you'll begin the online questionnaire. This is where you provide all the necessary information for your will. Think of it as a guided interview, broken down into easily digestible sections. LegalZoom's platform is known for its user-friendly interface, making it accessible even if you're not particularly tech-savvy. The first crucial step is identifying your assets and debts. This involves listing everything you own, from real estate and bank accounts to investments, vehicles, and even sentimental items. Don't forget digital assets like cryptocurrency, online accounts, and social media profiles. These are increasingly important to include. You'll also need to outline your debts, such as mortgages, credit card balances, and any outstanding loans. Having all this information organized beforehand will significantly streamline the process. So before you even log on, take some time to gather bank statements, property deeds, investment account details, and any other relevant financial documents. Next, you'll designate your beneficiaries. These are the individuals, charities, or organizations who will inherit your assets. You'll need to be specific here. Instead of simply saying, "my family," you'll name each person or entity and specify exactly what they will receive. For instance, you might designate your primary residence to your spouse, a specific sum of money to your children, or a percentage of your remaining assets to a favorite charity. It's also wise to name contingent beneficiaries. These are the backup beneficiaries who would inherit if your primary beneficiaries are unable to. This provides an extra layer of protection and ensures your assets go where you intend, even if unforeseen circumstances arise. One of the most vital decisions you'll make, especially if you have minor children, is appointing a guardian. This is the person you trust to raise your children if you're no longer able to. Without this designation in your will, a court will decide who raises your children, and that decision might not align with your wishes. LegalZoom will prompt you to name a guardian and, if you wish, a successor guardian in case your first choice is unable or unwilling to serve. You'll also appoint an executor for your will. The executor is the person responsible for managing your estate, paying your debts and taxes, and distributing your assets according to your instructions. This should be someone you trust implicitly, who is organized, and capable of handling legal and financial matters during a difficult time. LegalZoom will guide you in naming both a primary and an alternate executor. With that said, thanks for watching, and until next time.